When a public school prohibits its football coach from praying with students during a football game, is that a violation of First Amendment? Or is it a valid attempt to avoid an Establishment Clause violation? To find out, you have to read Kennedy versus Bremerton School District, but it's 65 pages long. Don't have time for that? I've got you covered. This is Too Long Didn't Read, where normally I cover New York Court of Appeals cases and try to review them in 5 minutes or less. But this episode is part of a limited series I am doing on landmark United States Supreme Court cases. This is the episode on the case of Kennedy versus Bremerton School District, published by the Supreme Court on June 27th, 2022. The citation for the case is 597 U.S. 507, 2022. The issue in this case is whether a public school football coach leading public school students in prayer violates the Establishment Clause of the First Amendment and whether the school is allowed to prohibit that coach conduct. To best understand this case, it's helpful to know a little background. The First Amendment to the United States Constitution protects several activities. It begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. In that short section, we see that it makes several guarantees. Number one, the government cannot establish an official religion or force people to pray a certain way. This clause has been interpreted to mean that public schools, as government entities, cannot endorse or promote religion. This is called the Establishment Clause. Number two, the government cannot stop people from exercising their own religious practices. This is called the Free Exercise Clause. Number three, the government cannot impair people's ability to engage in free speech. This is called the Free Speech Clause. The Kennedy case presented a clash between these fundamental freedoms, forcing the court to determine where one person's right to religious expression or free speech might infringe on the rights of others not to have religious opinions imposed upon them. So, what are the facts? Joseph Kennedy was an assistant football coach at a public high school in Bremerton, Washington. Coach Kennedy had a practice of kneeling at the 50-yard line after games to offer a brief, quiet prayer. Initially, Kennedy prayed alone. Over time, students began joining him and his prayers became more overtly religious. When the school district learned of Kennedy's activities, they asked him to stop, citing concerns about endorsing religion and potentially coercing students to participate. Kennedy argued that his prayers were private speech protected by the First Amendment. He maintained that he never required or encouraged students to join him. The school district, however, contended that Kennedy's actions were not private, but rather public displays of religion that could be perceived as school endorsement of his religion. They argued that students could feel pressured to participate, fearing favoritism or exclusion by the coach. Eventually, the school district told Coach Kennedy that he was prohibited from continuing his prayers during the game. After a series of back and forths with the school district, Kennedy continued his post-game prayers. The school district placed him on administrative leave. Kennedy sued, alleging a violation of his First Amendment rights. The case wound its way through the court system. A federal district court sided with the school district. The Ninth Circuit Court of Appeals upheld that decision. The Supreme Court, recognizing the significance of the case and the conflicting rulings from lower courts on similar issues, agreed to hear Kennedy's appeal. How did the Supreme Court decide the case? In a 6-3 decision, the Supreme Court sided with Coach Kennedy. The majority opinion, authored by Justice Gorsuch, held that Kennedy's prayers were protected free speech and did not violate the Establishment Clause. The court reasoned that Kennedy's prayers were private speech, even though they took place in a public setting. The court emphasized that Kennedy was not speaking on behalf of the school and that his prayers were brief and did not coerce participation. But the dissenting justices, led by Justice Sotomayor, argued that the majority opinion mischaracterized the facts of the case and ignored the potential for coercion inherent in a school employee, in particular a football coach praying with students. They warned that the decision would open the door to more overt religious displays in public schools, blurring the line between private faith and government endorsement. The Kennedy versus Bremerton decision has significant implications for the future of religious expression in public schools. The case has reignited the debate over the balance between religious freedom and the separation of church and state. It remains to be seen how lower courts will apply the Kennedy precedent and whether the decision will lead to more litigation over religious expression in public schools. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.